Sit down.
In session, please be seated.
Thank you. All right, do we have any preliminary matters before we get started? Everybody settled and okay? Well, let me just say, if this is the worst thing you ever do in your career, you will be very fortunate. So, no worries on our part.
Not at all.
All right, if there are no preliminary matters, want to call the case?
Brett W. Houghton et al. Versus Malibu Boats, LLC.
Good morning. Taylor Williams of Payne Bickers in the Knoxville Bar on behalf of Malibu Boats LLC. I'd like to reserve 5 minutes for rebuttal. Following a multi-day trial, a Loudoun County jury awarded to the Houghtons, who were individual shareholders of a corporation called Great Wakes Boats, $0 for their personal expenses that they allege that were incurred as a result of misrepresentations made by my client, Malibu Boats. The jury further awarded them $0 for their individual pain and suffering as a result of Malibu's alleged misrepresentations. Finally, the jury awarded them $0 for the value of their shares, or diminution in the value of their shares of the corporation, Great Wakes Boating. The jury did, however, have one more line item, and that line item was there at the insistence of the Houghtons. And it was a line item included separate from the diminution value of the shares of the corporation. And that line item was for the loss of equity in dealership buildings, and that's Trial Exhibit 89. Loss of equity in dealership buildings. In other words, the Houghtons expressly asked for equity in a piece of property that they did not own. Now, to allow this result would violate public policy of the state of Tennessee. It would allow the trial court and all courts of Tennessee to exceed the authority granted to them under the Tennessee Constitution, specifically Article 2, Sections 1 and 2, the separation of powers.
Mr. Williams, it allows it only when a defendant fails to object to that, right?
I missed the first part of your question.
Isn't this sort of a mess of your client's own making, in that that there are, assuming this is non-constitutional and requires, an objection to the shareholder standing at an earlier point in the proceeding? I mean, isn't that the way to preserve principles of corporate separateness, to actually raise the objection?
Certainly, it could have been raised at an earlier time. That is without a question. However, there's a difference between the litigants making arguments and when a court turns it into a court order exercising their authority. And when a court exercises its authority by allowing, in this case, effectively a distribution to shareholders to the detriment of creditors that have $1.2 million worth of consent judgments, it becomes an action of a court that is beyond or in contravention of the legislature's statute that distributions cannot take place. So
why wasn't this argument made to the trial court?
Well, it was made to the trial court.
Well, after the trial and the motion. So why was it not made sooner?
As this court's probably aware, I was not the trial counsel. I do think, however, from the record, there was some confusion as to whether or not the Houghtons were asking for their damages from signing personal guarantees, for which they had no damage because they were not called on the personal guarantees. But that possibly could be a direct claim, versus whether they were asking, and what they insisted on being on the jury verdict form, actually receiving equity, an award of equity.
All those are things that are sorted out at trial.
They can be.
That should be sorted out at trial. I'm not hearing an answer about why it was not made here.
Again, I think there was some confusion as to what the Houghtons were asking for, and specifically even during closing, there was question about whether it was their buildings or the corporation's buildings.
Well, if there was confusion, then you raise the argument to preserve it, and then you see how everything plays out. But I mean, the argument just simply was not raised. There was no argument that the shareholder plaintiffs lacked standing
And I'm
until
not,
after the verdict.
I'm having a difficult time also understanding how there was some confusion with the term loss of equity. I mean, that doesn't seem to be too confusing. If there's equity in the building, it's going to go to the owner of the building.
There were, in fact, questions about whether or not the alleged liability, the alleged wrongful conduct, that there are misrepresentations that caused the Houghtons to take some sort of action, actually could flow through to anything related to the building. Okay, so there were factual challenges, and that is included in the JNOV, as to whether or not there was evidence as to tying the wrongful conduct all the way through to the refinancing or a diminution of value, loss of equity in the building. So it was argued in that regard. It was not raised as standing. And so it's not that it entirely went missed. However, to allow this to take place still, regardless of whether it was waived or not, would allow a path for a Tennessee court to award to shareholders a distribution when the corporation cannot pay its debts, the $1.2 million in consent judgments.
We have lots of statutes that specify what kind of party can file X kind of action. Look at the wrongful death statutes, for example. All those matters are litigated at trial where they should be, because there are so many factual nuances that are involved. Here, for example, there can be dual claims, as you mentioned. It's not always clear, and there might be sorting out that takes place at trial where the plaintiff can put on this kind of evidence, they can't put on this other kind of evidence, but that's with full transparency about the issues where everybody hashes it out at the trial level. The essential question in this case is whether it's jurisdictional. Why should, nobody is saying that the wrongful death statutes are jurisdictional. We see appellate cases all the time sorting out who can file what kind of claim. Why is this any different?
It's different for two reasons, Your Honor. One, we're dealing with a corporation, not with individuals, and corporations are governed by statute, and the legislature has inserted itself into the province of corporations. The second reason is that a derivative action has been statutorily defined as having statutory filing requirements, which of course touches on statutory standing. And if those requirements are not met, then the trial court has no jurisdiction. The same is in a divorce proceeding, a petition to terminate parental rights, writs of certiorari from inferior courts. And so the reason that it's different is because it is a corporation, and the legislature has exerted its province over corporations, and because it truly should have been a derivative action in order to acquire the corporation's harms to the corporation.
Well, but the legislature oftentimes has statutes dealing with causes of action, whether they're corporations or not, whether corporations or individuals. There's any number of examples of that. So why is the defining line corporation here?
Well, because the corporate veil is typically used as a shield against liability. And it has been recognized by the legislature that could be used wrongfully, correct? It could be used for shareholders to, and so.
And I'm not disagreeing with you that the statutes are there, and that if they're followed, that this judgment likely would not have held up. But the point is, if those statutes aren't followed, that doesn't void the case. It doesn't void the case when any statute is not followed, does it?
Well, if it touches on subject matter jurisdiction, it can.
Yes, subject matter jurisdiction.
And statutory standing does touch on subject matter jurisdiction, as this court has held on several occasions. And because Malibu's position is that this only could have been a derivative action, and it was the filing requirements, the verification that it be brought in the name of the corporation were not followed, then the derivative cause of action, the trial court never obtained subject matter jurisdiction over that claim. And that was the only way it could have, specifically over the equity in the property. There was jurisdiction over the individual claims. And so that's one thing to keep in mind, is this wasn't an all or nothing. It's easy when we talk about subject matter jurisdiction to get brought into the federal court idea of I destroyed diversity jurisdiction, the court says I'm done. Tennessee courts are courts of general jurisdiction. There were claims over which the trial court had subject matter jurisdiction, just not this one. And that
Which ones did, I mean, what's your position about which claims were properly before the court?
So, and to get into the facts, the plaintiff showed up to a boat show, the Knoxville Boat Show. They had spent their own money to show up to the boat show.
So like the personal expenses.
The personal expenses.
Okay.
And when they showed up, there was another dealer there. They were embarrassed by the fact that there was another dealer there. That pain and suffering that was also on the verdict. And this is where shareholder standing actually comes into play. Had the jury awarded the diminution in value of the business, that is, they owned those shares. They had a legal harm from any decrease in value of their shares.
Well, so I understand your point that, these were listed separately on the verdict form, et cetera. But, I mean, certainly there was indirect harm experienced by the plaintiffs in the form of the loss of this value. I mean, they were the sole shareholders of this corporation, correct? I mean, the fact that it was articulated a little bit differently on the verdict form, that those two things were separated out, doesn't change the fact that, if we're looking at kind of what harm they suffered, and that will bring me to a different question in a second, but there certainly was injury here, albeit, I think, indirect from the loss of the value in the corporation. Would you agree with that?
Not exactly as phrased, but in general idea, it brings us to the where you all get to enjoy me speak Latin, danum absque injuro, that was discussed so frequently in the Wilmington Trust case. There can be an injury in fact without an injury in law.
Okay, so let's move to that, because of course after the briefing in this case was complete, we did issue our opinion in the Wilmington Trust case, which modified the constitutional standing doctrine in private rights cases. I mean, this is a pretty classic example of a private rights case. What you just seem to have argued is that even if there was injury in fact, this may be a case where there is no injury in law. So I'd like to give you an opportunity to kind of address how you think this plays out under the framework we adopted in Wilmington Trust.
Okay, and I think there's been a lot of discussion of waiver of my client, and the record is what it is. There has to be some discussion about waiver and decisions that were made by the plaintiffs in the case to have the separate line item. And because there may have been both legal harms, and I think, having looked at these cases, saying injury and damages keeps it a whole lot cleaner than injury and injury in fact. There may be damages related to the building that, as Your Honor mentioned, indirectly flowed. That doesn't mean there's legal harm. There was a legal harm with regard to the value of their shares in the corporation, but the jury very specifically found there was no damage. And so there were legal harms that the Houghtons brought before the trial court, and this is under the Wilmington Trust and the Latin doctrine that I won't butcher before you all again. But that maxim, that they had legal harms, the jury found no damage, no injury in fact.
But weren't those legal harms still derivative of the legal harm to the corporation, or were those somehow independent? Because I see the same legal harm here. I mean, they're still alleging, misrepresentations, fraudulent concealment, all of that, as to them as shareholders. It's just that the claim is sort of one belonging to the corporation under our shareholder standing doctrine.
So under the 2016 case Keller, this court went through a lengthy analysis of the Delaware's Thule analysis and what is direct and what is derivative. And it found that shareholders always have standing to bring their direct claims, and in this case that would be their personal expenses, their pain and suffering. They also, assuming that a defendant does not object to shareholder standing, can bring direct claims. derivative claims. Derivative claims do not mean that a shareholder gets to recover for the value of a specific asset in a corporation. What it means is that shareholder can then recover for the general decrease in value of the corporation. My shares went down in value. That is the derivative claim that is allowed.
But they were the sole shareholders here. Does that change the analysis?
I don't think, Your Honor, it does, because it has been the public policy of this court and of this state, as far back as I am aware of, that corporations and its shareholders are separate, and that only in special circumstances can that be set aside. And just a closely held S-corp has been found to be not such a special circumstance, and that was also mentioned in the Keller as well as the prior case that I'm blanking on. I apologize. So I think, and this is what we tried to make clear in the reply, is perhaps they had standing to make direct claims, perhaps they had standing to make derivative claims. What they actually made was neither. It was a request to personally recover for the value of a specific asset in a company, not for the value of the company at large. But I want the value of that right there. Shareholders don't have that right. They don't have that legal harm. There's nothing in the Tennessee common law, in the Tennessee Constitution, in the Tennessee statute that says a shareholder can reach through the corporate veil and grab onto an asset and say, I want the value of that. And we know that's what they did because it says equity in the building. They reached through the corporate veil, grabbed onto the building and said, I want that equity. Not anything else. I want that. Not a value of the company, I want that. And that
was there evidence presented as to the value of the shares in the corporation? And, did that reflect the loss in equity in the property?
Certainly, Your Honor, there was a discussion of an appraisal of the building and then later the foreclosure sale of the building. With regard to the enterprise at large, I apologize, I don't know that. I believe that there was. I think it was introduced through the form of sales. We had X number of sales, and then we were effectively defunct, by this date.
So it was more based on the inventory.
Or a drop in sales and a drop of operation, correct. I don't think because it
didn't reflect the value of the assets.
Correct.
So how would this issue have been preserved in the record?
Well, the fact that Malibu did object to whether or not the wrongful conduct could be linked to the specific harm, it was from an evidentiary standpoint preserved. From in the specific nomenclature of standing, it was raised before the trial court. It was not raised during trial. It was not raised in the paper of the JNOV. It was raised before the trial court. Thus, at a minimum, Malibu did present to the trial court an opportunity to consider its own jurisdiction. And so from that standpoint, it was preserved. And as mentioned, it is we believe, a jurisdictional issue, a separations of powers issue, and of course, the Latin maximum as well.
Okay, so what I think I'm hearing is that the first time that it was raised in the context that we are considering it today was at the argument on the JNOV.
That's correct.
And you're saying that the actual motion for JNOV did not raise it either, correct?
That is correct. It again challenged whether or not there had been evidence tying any wrongful conduct to their personal interest in the building, but it was not phrased such as standing.
Going back to the frameworks set forth in the Wilmington Trust case, explain again how this case is not just your run-of-the-mill private party action that, as I interpret Wilmington Trust, would say the plaintiffs had standing in this case. They may not recover, but they have standing.
Okay, so the first aspect of that question is this a private action? Yes, undoubtedly it is. Thus, the three-part test in the city of Memphis no longer applies to this case. I think that was pretty straightforward. I think, though, that Wilmington Trust did not say that standing can never be an issue in any case. It said that standing can be a problem where doctrines such as separations of power and the Latin maxim as constrained by the open courts provision, that there can be, whether you call it standing, whether you call it separation of powers, that a court can reach the outer limits of its jurisdiction under the Constitution by effectively entering an order or allowing a case to proceed where the plaintiff does not have a legal injury. And that is what we're saying is, vis-a-vis the real property, the plaintiff had no legal harm, even if they had an indirect damage. They had no direct actual legal harm. There's no recognized cognizable right under statute, under Constitution, under common law that says I can get the value of a corporation's specific asset.
But, so why isn't that just regular failure to state a claim, that sort of thing that is sorted out at the trial court level? When the objection is raised at the trial court level, people have an opportunity to reconfigure their proof, the questions to the jury, that sort of thing. I mean, what it sounds like you're just saying is that this plaintiff, as to this particular claim, failed to state a claim against your client. So, I mean, failure to state a claim can be forfeited, all of that kind of stuff. I'm not following the jurisdictional argument.
If the challenge were to the injury in fact or the damage, then I would agree with Your Honor, that can be raised. And certainly this could have been raised earlier. There's no question about that. But just because something isn't raised earlier, if it does touch on constitutional issues, does not mean that it is waived. And so, yes, it could have been brought sooner. But the fact that it wasn't doesn't mean that the issue is not still live today, because it does touch on constitutional issues and specifically standing and separation of powers. And so, if Your Honor's concern is...
In Case versus Wellington
Yes.
Trust, are you relying on particular language in that case, or what are you...
Specifically, the maxim as articulated, if you give me a second, Your Honor, that, and I believe is on page 9, a damage to one without injury in law does not lay the foundation of an action. And Your Honor suggested in the concurring opinion that perhaps the open courts clause was being used to restrict as opposed to expand whether a plaintiff can present to a court. And as I interpret it, which is a dangerous proposition, but as I interpret it, the legal maxim has existed since the English common law and has followed through all of Tennessee common law and jurisprudence. The open courts clause places a limit on that. But the underlying maxim exists that if there's not a cognizable right in law, then the court provides no remedy to you. The doors are not open to you. The open courts clause is the limitation upon that. And so there's a case that hasn't been briefed in any of the briefing because it's tied or it rose out of the Wilmington Trust, but the Smith v. Gore case, which was a 1987 case about a failed pregnancy prevention procedure. And in that, there was the same, this court looked at other high courts, and other high courts said, they relied upon that maxim and said, look, you're not legally harmed. And this court said, we're not going to just come up with ethereal public policy and tie it to this maxim. Instead, we're going to look at the public policy of the state of Tennessee. We're going to look at the statutes in the state of Tennessee. And in that case, they said there are statutes in the state of Tennessee that say that parents are obligated to maintain and support their children, and we're not going to allow a tort claim to shift that burden onto a doctor. Okay, that's effectively what the court said. And respectfully, we submit that this case is almost identical in that the legislature has said that corporations can only make distributions to shareholders if it will not harm their creditors. And that is the stated public policy. And if this is allowed to proceed, then that public policy, that statute will be totally abrogated.
Do the creditors have remedies here against the plaintiffs directly?
The plaintiffs have come out of bankruptcy, so no, I do not believe so.
I mean, what I'm struggling with here is, if you look at the Third Circuit's recent decision in the Potter case, I think the reasoning there, to me at least, seems fairly sound. And that opinion points out that, shareholder claims are a little bit unique in that they are not, you can think of some third-party claims are truly like one party wholly asserting a claim belonging to someone else, where that plaintiff party, didn't actually suffer the harm. That arises sometimes in abortion cases where you have the abortion providers asserting the claims of their patients.
Right.
But, what we have in shareholder cases is the shareholders have suffered, at least indirectly, some harm. And certainly in the case of, where you have sole share, where the
Right.
plaintiffs are the sole shareholders of the corporation, they were involved in the actual representations that were made. They're bringing claims of misrepresentation. So, this seems to be a situation where, there are legal injuries and factual injuries, but, it's just the case that we have decided sort of as a matter of, or that Tennessee has decided as a matter of policy and corporate principles of corporate separateness that, this is really a claim belonging to the corporation. And that seems to be more a prudential matter. It's really, a lot of courts have analyzed this under the real party and interest framework, under the rules of civil procedure, because that's kind of what it is, right? It's just that there's a different party that is better situated to, or as a matter of policy, should be bringing these claims. And so that seems much more prudential than jurisdictional to me.
So I'm out of time, but if I can briefly respond to that. One, Potter dealt with derivative and direct claims. What the Houghtons have introduced is neither. Two, it is not simply a matter of whether or not, it's not simply prudential, because Tennessee is somewhat unique in that its derivative action claim. Most states rely upon an allegory of Rule 23 of the Federal Rules of Civil Procedure. We have the same in the Tennessee Rules of Civil Procedure, Rule 23. Ours is actually codified and has a requirement that it be verified and brought in the name of the corporation, which means that the action brought outside of that is actually in violation of the statute.
Well, but you've said this isn't a derivative claim.
I've said that the only way that the trial court could have awarded these damages is through a derivative claim, and that was not brought.
And so your position is that the only way a shareholder can bring a claim involving of harm to the corporation is through the vehicle of the derivative statute.
And in violation of that statute, it simply cannot be brought unless it is outside the court's jurisdiction under the separation of powers issues.
Thank you, counsel.
Good morning, may it please the court. I am Dale Montpelier, and I am here for the plaintiffs. And clearly you have a good grasp of the background facts, but I think the essential thing is the jury found 3 different types of intentional fraud against Malibu's highest level executives after a 5-day trial. All of those instances of intentional fraud are direct claims. There's no question that my clients brought direct claims. The jury, on the jury verdict form, they selected one category of damages, the value of the building, and I think as a matter of accounting principles, it's a fixed asset. It's part of the value of the business. Now, the defendant failed to raise its standing defense, and I would reference your case, Nerum versus Leatherwood, and it's pretty clear. Standing can only be contested in a specific denial in the answer, and a 12.026 motion to dismiss, and a 12.03 motion for judgment in the pleadings, or a 12.06 motion to strike, none of which happened here.
Well, that assumes the standing issue is a prudential issue, though.
Correct.
And counsel, I think, is arguing that this is not prudential, this is constitutional standing.
Right. Well, and of course we disagree with that. But something I think really needs to be focused on, They're saying that these need to be derivative claims. We didn't bring derivative claims. Like Judge Sweeney said, it's no surprise they didn't follow the statute. They brought direct claims. What the defendant is arguing with is a specific category of damages. And apparently they're saying a category of damages needed to be derivative.
If I could interrupt you for a second, could you explain in more detail how these are direct claims under the analysis in Keller?
Well, the intentional misrepresentation, fraudulent concealment, and promissory fraud were all directed to the Houghtons, and they were owners of the business. They would not have signed or continued this. They wouldn't have refinanced the building personally. They would not have personally guaranteed.
But how is the financial harm not derivative of the injury to the corporation? How is there a direct injury to the Houghtons based on the loss in equity?
Well, they did raise as my colleague pointed out, they did raise direct harms to them.
Well, but I'm talking about the specific harm for which the jury awarded damages, which was the loss in equity.
Well,
How is that a direct a direct harm to the Houghtons rather than a harm that was derivative of the harm to the corporation?
right. And I think this goes to the Wilmington Trust case, where it says a violation of legal rights in some way, a violation of law that affects a person adversely. Doesn't matter whether there's injury or fact or damages.
Well, right, but so you've kind of moved on to standing, but I'm just focused on how this is a direct claim instead of a derivative claim, and I don't think you've answered my question yet about how this is the financial harm to the Houghtons is not, I mean, it seems to me it's entirely derivative of the harm to the corporation. I'm not quite understanding how it's not.
Okay, well, I think there's, part of it is direct and part of it is indirect. I think the direct injury is they had a right that nobody interfere with their stock. That is a private right. Now, the indirect, it's damages, which they can't recover, belongs to the corporation, but they had an absolute right that their stock not be interfered with. There's also the personal guarantee. And I was thinking of an analogy. My son's car. I personally guarantee his loan. It's his car. But I personally guaranteed his loan. If somebody wrecks that car, they have directly damaged me. Indirect, I can't get damages, but they did damage me because I personally guaranteed that loan. So that would be my response to that.
The Houghtons declared bankruptcy, correct?
Excuse
so, I
me?
mean, they were never, their guarantee of the loan, they didn't actually suffer financial consequences stemming from that.
My
Is that
understanding
correct?
is that guarantee was called. And once we start looking at whether they suffered harm or not, now we're getting into an analysis of whether they actually suffered the damages. And under Wilmington, we don't look at whether they actually did.
I really am still trying to figure out if this is a derivative or a direct claim. I agree that the standing analysis is separate, but I think we do sort of need to sort out whether these were what kinds of claims these were to determine what the legal injury would have been.
Right.
For purposes of the standing analysis.
That would be our position. I mean, their stock was interfered with by a third party, and they have a right. Well, for lack of a better word, their stock shouldn't have been molested by a third party, and it was.
So how does that figure here? Because they weren't actually awarded damages for diminution in the value of their stock.
Well, Your Honor, and this is where I touch in on this, and at the jury verdict form, which of course the defendant approved, there was a question on whether that value could be recovered. The building is a fixed asset. It absolutely ties into the value of business. If that fixed asset is removed from the balance sheet, that is a serious impact on the value of their stock. So the fact that it was separated out, I think the overall value is you got to look at both lines. One was zero, one was 900,000. So, I think I covered the Wilmington Trust case. Like I said, the issue isn't damages because we don't look at that. We just look on whether a legal right was violated. Then we come to the statutory standing, and of course in the city of Memphis case, you're looking at whether a statute designates somebody who can bring a cause of action, like the termination of parental rights statute is very crystal clear in who can and who can't. Now, in this case, there is no statute that says only this person can seek a certain category of damages. So even if they are derivative, the statute does not specify that they have to use a derivative action. And I reference a lot in the brief your case, Keller versus Estate of McRedmond, which discusses who can recover damages to a corporation. Now, the Keller decision did not reference a statute. It referenced common law. In fact, it adopted Delaware common law. Keller had nothing to do with statutory standing. And then a few things, two quotes. It says, in most circumstances, the proper party to bring a claim on behalf of a corporation is the corporation itself. Well, in most circumstances, it shows that it's not jurisdictional statutory standing, or there wouldn't be other undefined circumstances where that didn't have to occur. And at the end of the decision, your honors say, well, not you, your predecessor honors, the buyers urge this court to make an exception to the general rule prohibiting a shareholder from asserting a claim belonging to the corporation. If this were statutory standing, it would not be a general rule. It would be an absolute rule. So this is waivable non-jurisdictional standing. And under this case, the defendants waived it. It was not in any other
I mean, if they had raised this argument at the appropriate time, do you agree that these claims ought to have been dismissed?
Yeah, I do. Yes, I do.
And why is that, I guess, if you're also arguing that these are direct claims?
I don't understand.
Well, I thought I understood your position previously to be that these were all direct claims.
Yes, they are.
And under Keller, their shareholders are allowed to bring direct claims, right?
Right, but again, we go back to they may not have been able to recover the damages, which is indirect. And that's
So
why...
are you saying that there's kind of a mismatch, I guess, between the claim and the damages?
Yes, just like under the Wilmington case, there is a mismatch. You don't have to show that you can actually recover the damages. You just have to show that you were injured in fact, and my clients were injured in fact. Their stock was injured. Their personal guarantee injured them directly. Now, indirectly, they can't recover damages, but that's not what you look at under that case.
But I'm a little confused too then. So if that's your position, and as Justice Campbell asked you, if a motion had been filed prior to the jury verdict to dismiss that claim, your position is it should have been granted, correct?
Well, I can't, I'm looking in hindsight. And looking in hindsight, studying the law as I have, it probably should have, yes.
And what would have been the basis for the dismissal?
Lack of standing. But they didn't raise it. They waited too late. And quite frankly, Your Honors, if they would have raised that defense earlier, that line item wouldn't even appeared on the jury verdict form. Clearly, this jury was upset with Malibu.
So just to be a little bit more precise, so you think the argument that could or would have prevailed had it been raised at the appropriate time is a kind of an argument grounded in our common law shareholder
Yes.
standing doctrine, not statutory standing,
Right.
but just
It's
the common law
squarely under
shareholder
Keller. Yes,
standing
Your Honor.
doctrine.
Yeah, sorry to speak over you. but-
No, that's okay. And so, again, I still am, I don't know that we're going to resolve the confusion. I still am a little bit confused about why that's the case if you're also arguing that these claims were direct claims. But I don't know that we're going to sort that out. So feel free to move on.
Well, Your Honor, I think the bottom line is we're not dealing with jurisdictional issues. Yes, perhaps the motion would have been granted, but they didn't raise it, and it really prejudiced the Houghtons. Like I said, that line shouldn't have appeared on the jury verdict form, and it wouldn't have had they raised it timely. And they waited until after the jury ruled. They waited until after they filed their post-trial motions to come up with this unique subject matter jurisdiction argument. I'm sorry, it's too late.
So you think, So your position is that that loss in equity really was a kind of subset of the loss in value in the shares?
Absolutely.
Okay. And why is, I'm not, so, but that is derivative. You would sort of concede that that is,
The damages,
yeah,
the monetary damages, yes.
okay.
But like I said, it would have been nice if I could have conceded it before that jury verdict form went to the jury. Is there any other questions I can answer? It really is we feel a straightforward argument. There's no statute that covers it. There's no statutory standing. There's an injury.
So
although-
there, I would agree. So most courts have said, I think, that have discussed the third-party standing doctrine. Most courts that have examined it have treated it as prudential, not a matter of subject matter, constitutional standing or subject matter jurisdiction. But there have been, some separate opinions suggesting that, that it may be constitutional in certain circumstances where you have, a plaintiff wholly asserting the rights of another party. So it's not their own, even in kind of a private rights case where all you have to have is a legal injury. If the legal injury being asserted is not your own, but a legal injury involving a third party, that perhaps then it could go to the court's subject matter jurisdiction. I mean, do you think this case is distinct from that situation?
I do.
Okay, in what way?
Well, first of all, I stand on the fact that they suffered direct injury. Their stock shouldn't have been tampered with, and it was. And their personal guarantees, personal. Those are direct injuries. Now, they can't recover the damages, yes, true. But that's not what we're looking at under Wilmington. And I'd add this, Your Honor, if we look back at the Keller case when it speaks of a general rule, what that would have said is there is no general rule because you don't have constitutional standing, and that's not what the case says. And you'd be closing what would be a potential avenue of redress in the future. Granted, you did not define what these other circumstances may be. I think that this case articulates one if you don't raise your standing defense in a timely manner. That's how I look at that.
Thank you, counsel.
Thank you.
Justice Campbell, I wish I had thought of it myself, but I loved the phrasing derivative of derivative, because that's really what we're talking about. It's not a direct or a derivative claim. They want a derivation of the derivative claim, which is a specific asset. And that is why it is different. And if we go to the analogy made about the car co-signing, in the event that the co-sign is called because of some various reason, and there's a tortfeasor to blame for that, perhaps counsel could get the amount of money paid under the co-sign, but it never gave him equity in the car. If he didn't own it now, he won't own it in the future, even if the co-sign is called. They didn't own the property beforehand. The fact that they may have been called, even though it was bankrupted and they never actually paid anything on it, on the personal guarantees, they never had equity in the property.
Well, all right. I'm going to drag you back to the issue you fear most, whether it's prudential
might that be?
or jurisdictional, because the whole question of shareholder claims, whether they're derivative or whether they're direct, you're saying that should be jurisdictional, where we come in after the fact. But those issues, we can talk about the facts of this case, but we have to issue a ruling that would apply in every case. If you look at some of the cases out there on trying to sort out, is this a derivative claim? Is it a direct claim? Is it a dual claim? Is it is it part of this claim, part of this? Enormously, factually complicated. how does that lend itself to being a jurisdictional matter where you come in after that's what you have to address, not just the facts in this case, but we would have to issue a larger ruling saying that that issue is jurisdictional. But if you look at some of the federal cases actually certify the question to the state court because it's so complicated and involves so many common law questions. You need to address that particular junction,
Okay.
that issue, and not just the facts in this case.
Your Honor, in this, I can answer that, but I can answer it both generally and in this case. It is, this court should enter a ruling that says that shareholders can never directly be awarded damage for one asset owned by a corporation, period. We already have an admission that this claim should have never been allowed, that it was not valid. We have that admission here today. It's been admitted before. And so this court is presented with two options. One, say that, yes, you can recover
But
whether
we
it's...
get to that issue only if it's jurisdictional. That was the crux of my question. Why should such a complex, factual determination where there are many different nuances and shades, why should we hold that that is a jurisdictional issue?
If it's the decision as to whether it's direct or derivative is a factual question that can be complicated. Whether or not a corporation owns an asset and a shareholder tries to get that one asset is not factually complicated. And so this court is presented with two options. One, put down a ruling that very clearly says, under the laws of the state of Tennessee, under the statutes set forth, the restrictions on distributions, when a corporation cannot pay its creditors. That's one way to go, that cannot happen. Shareholders cannot benefit from a single asset. The other is that an admission that creditors, $1.2 million worth of consent judgments, are going to miss out on a potential $900,000 collection because somebody else, the tortfeasor, didn't raise an issue. And to me, that's a much more dangerous proposition than simply saying shareholders cannot reach through the corporate veil. When keep in mind, the corporate veil is still there to protect them from the $1.2 million worth of consent judgments, but they're allowed to reach through it to grab onto an individual asset. And I think that is a much more dangerous proposition for this court.
But to kind of go back to my first point, I mean, as long as there's an objection timely raised, we won't have that problem.
Certainly, although, and I can't think of any off the top of my head, but I'm certain that there are plenty of times when this court has ruled that some action goes beyond its jurisdiction or veers into a potential separation of powers issues that could have been addressed by the defendant. I'm not sure that is that retrospective view of, well, the defendant could have done something differently, changes the constitutional analysis for this court or for any court. I believe I'm out of time unless Your Honors have anything else.
Thank you both for your fine arguments and for bringing this case to us. The case will be submitted, and that completes our docket for today.
All rise.